Hi everyone, I know that some of you missed a lesson with me regarding loss of control defence, which is going to be one of your assessments this coming week for 10 marks. So I'm just making this video to go through how you would approach this sort of question. So the first thing to do is to look at your notes and to condense down the topic. So this topic is voluntary manslaughter. We're not dealing with diminished responsibility at the moment, but it's going to be, as I said, a loss of control question. So on the AQA spec, you can expect short answer questions, and you will have a 10 marks question. That means that unlike in the 30, the question for 10 marks will tell you exactly what the topic is. And as I say, this is loss of control. So you are to assume that murder has been proven, and you don't need to discuss the actus reus or mens rea of murder at all for this 10 marks question. So if I make this a little bigger, what I've put here is the defence, and it really comes into three parts. And the first is the defendant must have suffered from a loss of control, hence the title, and I'm just really putting the sort of bare minimum that we need in here. So as you can see, my legal authority, you need to support each point with a legal authority. It's usually a case. This is also statutory. So for that reason being, I think I would also add in here, if I move that up, where the defence can be found. So this is section 54 of the Coroners and Justice Act 2009. So I'm just going to pop that into red. Okay, right, let's go full screen again. So as you can see here, statutory defence from an Act of Parliament, and you need to try and remember the section number and the statute when you're introducing your answer for this defence. But the first thing is they must have suffered from a loss of control. So the case of duel will be the one that we rely upon, and one of the changes to this defence from the old defence of provocation is this loss of control defence no longer, the loss of control no longer needs to be sudden. There has to be, however, sufficient evidence, which in the duel case there wasn't. There was evidence that it was a premeditated killing because the defendant was discovered with a survival bag or survival kit that showed that he had planned and certainly his escape and kind of knew what he was doing, rather than the claim that he had periods of sort of blackness and a blackout and he didn't recall the killing. After which there must be a qualifying trigger. So with this being voluntary manslaughter, it's clear that the defendant has voluntarily killed someone, but this defence is essentially providing an excuse that the law will accept. The defendant killed someone, but it was for one of two potential triggers that the law will allow. Now the first one is out of fear, and that's fear of serious violence from the victim to the defendant, or indeed from the victim to another person. And then B, which is regarded as sort of the anger trigger, which is things said or done that are of grave character and leave the defendant feeling seriously wronged. So we discussed this in class, and certainly one of the things that this new defence compared to provocation has changed is that it's added in grave character, feeling seriously wrong. So for instance, the case of Dougherty, where a man killed his baby because it wouldn't stop crying, would no longer be of grave character. And then for instance we looked at another instance, the case of Hatter, where relationship breakdown, which sadly is quite common, is again not a sort of acceptable trigger for why someone could lose control and kill. So the threshold, the bar, is set quite high. A further change with this defence compared to the old one of provocation is sexual infidelity is no longer an acceptable reason. So if you suspect that your partner, for instance, has been cheating on you, or even if you walk in on them cheating on you with another person, and then you subsequently kill them because you've lost control, yes, you will be in an emotional state, but the previous defence of provocation was criticised, particularly in domestic violence and domestic abuse cases, because typically it was men who would lose control and kill their partners, and it's no longer accepted in today's society that that should even be a reason for someone killing. So relationship breakdown is it's a commonplace thing. That's the case of Clinton. Revenge, again, the law will not accept. The law will not allow essentially the law to be taken into a person's own hands to try and mete out what they believe is justice by committing another crime. So revenge is not allowed. And then also the defendant cannot incite violence first, and then if the victim then fights back, and then the defendant kills the victim, they can't then claim loss of control because essentially they have started it. And we can see that in these cases because, as I said before, Clinton, the husband who was on a break from his wife, suspected that she was seeing other men, and he wanted to reconcile, but he ended up losing control and killing her, and then taunting, I think by contacting on her mobile phone the supposed lover that she had. So it's quite clear he was motivated in killing her just through sexual jealousy. Revenge in Bailey. Now I know Bailey is an older case that predates this defence, but it's still useful. And revenge here is where a father, I think, took revenge on a drug dealer by shooting and killing them because they had threatened and attacked his son. And then lastly, Dawes, which is a more recent case like Clinton since this 2009 defence. That is when the defendant returned home and saw that I think it was his partner or his wife, fully clothed but on a sort of sofa with another man, a stranger. And at that point the defendant lost control and I think got a bottle and started assaulting the man, who then woke up and began in self-defence really to assault him. And then of course the defendant then went and killed him, and he tried to claim this defence, but of course inciting, starting the violence first, promoting it, provoking it, is not a reason that's accepted. You'll notice I've put as well section 55, that's sort of our legal authority for this. If you look at the statute online, you will find that there are section numbers in the statute referring to sexual infidelity, revenge and so on not being allowed. If you feel you are able to remember those section numbers, then please do, but I've not included them in this video for the moment. And the third and final test, because all three elements of the defence have to pass, have to convince a jury in the Crown Court, is an objective, sometimes referred to as normal person test. And so here it is, would a person of the defendant's sex and age, those two key characteristics, with a normal degree of tolerance and self-restraint in similar circumstances, have reacted the same way? And really, although this is a question for the jury, you have to give your opinion in your answer. And it may be your opinion might possibly differ from another person writing the answer, but as long as you can back it up and give a reasoned view, that should be enough. Now I think what makes this topic and a question in terms of loss of control more challenging is it's quite wordy, particularly if you look at the triggers like part B and you look at the normal person test, and you've got to try and learn these as close to the wording as possible to gain the marks for AO1, knowledge and understanding. So again, writing on flashcards, condensing them down like I have here, and you're welcome to print out this as a handout for your folder if this helps. Camplin, or indeed the case of Van Dongen, would be the supporting case for the objective test. Don't really feel the need you have to go through and explain the case facts or anything of that. Intoxication is not relevant, and that will only obviously be relevant if it's in the problem scenario. Asmelash is the key case that decided that. So finally, if the defendant is successful, This means, as a special defence to murder, and indeed a partial one, it will reduce murder down to voluntary manslaughter. So there is fault for the death, but there is, a lesser degree of fault on the defendant because, as I said earlier, it's accepted you either acted out fear or anger, and that means a lesser sentence that is not a mandatory life sentence, which of course a judge would have to give for murder. Now, what I've done next is I've created an exam question here, one that my students certainly have not seen before, because of course I can't really use AQA questions in videos for copyright reasons and so forth. So this is a typical sort of thing you might find for 10 marks. Nell is in an abusive relationship with her husband Dan. Although they have been married for approximately 10 years, in the last few years she has found that Dan's behaviour has changed after he accused her of flirting with a family friend during a holiday. Since then, Dan has become more controlling and saying to Nell what she can wear, who she can see, and over the household money and what can be bought. One day, Nell suspects that Dan is seeing another woman when she checks his Home Office computer and discovers a number of emails between him and a woman named Sarah, which are flirtatious. Nell confronts Dan about the emails and he denies an affair, telling her, "It's all in your head. She's a work colleague, nothing more. But she pays attention to me, unlike you. You're the world's worst wife." Nell rushes into the kitchen and returns with a kitchen knife, stabbing Dan several times in the chest, killing him. So, again, for a 10 marks question, typically on AQA, it would be something like, on the exam board, assume that Nell has committed the offence of murder, so we don't even talk about murder. Will she be able to use the defence of loss of control successfully? So at this point, at any time you can download the handout, you can pause the video, but I'm going to have a go at trying to answer this question with you to try and understand how structure will work. So I'm just going to do a new presentation. So we've got here, let me get a slide ready. And I always like to do the font in Arial because I think it's just easier to see. Right. So for those of you dealing with problem questions, and you've perhaps seen my previous videos, you will know that I have recommended using this sort of structure, this mnemonic, which is IDEA. So this is specifically for problem questions, although there are, I think, other alternatives. IRAC is another, which you can learn more about on my Law Google site. But for those who are unsure still about this, this is, in our answer to the problem scenario, we have to identify, we have to define, we have to explain, and we have to apply. So identify in terms of, who, what, offence or defence. Now, of course, in a 10-mark question, this is a lot easier because the question tells you, but in a 30 marks question on AQA, the question might tell you that it's for murder, but it won't ever tell you anything about defences, and you've got to look for them. And then define, in terms, for me, I use that to define, is it common law or statutory law, the actual offence or defence. And then for explain, so largely a lot of your work, a lot of the marks are in E and A. So explain will be essentially explain the law. So this is your assessment objective 1, knowledge and understanding. And apply is going to be applying the law to the scenario and basically reaching a conclusion. So assessment objective 2 and assessment objective 3. So assessment objective 2 is your application. So when you start saying, well, for instance, Nell suffered a loss of control because, and that, if you will, is you applying it. AO3, of which there are some marks available for problem scenarios in AQA, is analysis and evaluation. Now for AQA it's more focused in these sort of questions on analysis. So when you are explaining clearly why you're reaching the conclusion you are, or you are linking to a key case and perhaps explaining the relevance of that point of law to the scenario, that is really your sort of AO3 marks. So I hope that helps first of all set that out. What I'm going to do now, and it might be a good time for you to actually look at the handout separately, because I can't get the I'm going to flick between the scenario and this. So what I'm going to do now is I'm going to attempt to write an answer to this question. So just make the font size a little smaller. So the first thing I said we need to identify, and frankly the question does it for us. So I'm just going to do the following. Nell may be able to use the defense of loss of control for the murder of Dan. Okay. I could add in, I suppose, special and partial defense, which it is, but I've said who I'm talking about, and I've said the defense, and indeed the victim. So that would be yellow. We're going to mark that in a minute as identify. We're going to move on to D now, define. Now, as I said earlier, this is a statutory defense. So this is a statutory defense found under Section 54 of the Coroners and Justice Act 2009. So that's me defining where the law is. Again, I'll put that in an appropriate colour. At which point, essentially, whenever you're answering problem scenarios, really the main thing you're doing is having to explain the law first and then apply it. It's always explain, apply, explain, apply. The most common mistake students make with any of these, when they first attempt them, is they don't know or don't say enough about what the law is, the AO1 part first. They just jump in and say, well, you know, Nell, you know, was really angry and she should be able to use the defense because the husband did this or that. But you have to explain the law first to get those AO1 marks. And if you don't have that as a foundation, then you're limiting what you can get in terms of AO2 and AO3, your application marks and analysis marks. So at this point, all I'm doing, okay, is if I go back again, do you remember our slide where I laid it all out? This is our AO1. All of this is our AO1. So I've got to put that into my answer. All that is missing, really, is, if you will, after it, once we've finished laying out number one, is applying it to the scenario and giving us sort of our conclusion, our viewpoint. So, back I go, and I'm going to do this now with you. I'm going to say, firstly, the D, of course you can abbreviate in the exam, D for defendant, V for victim, absolutely fine. Firstly, the D must have suffered a loss of control. Now at this point I can just put the case in brackets if I want to, and that's dual. And that's my legal authority, and that's something that if you want to get, you know, as many marks as you can in these problem scenarios, you need to do that routinely, consistently, which is what I think it's band 3 or whatever the high band is for AQA. So what else did we say? Having suffered a loss of control, this need not be sudden, but there must be sufficient evidence of a loss of control. Okay? What do I need to do now? So I've covered the first bit. What I need to do now is apply it. So I'm going to look at the problem scenario, and this is where you have your highlighter pen out, be rather useful. Is there anything here that suggests she lost control? Well, I guess immediately I'm thinking this sentence is pretty relevant. I'll just put it into yellow for a moment. Nell rushes into the kitchen and returns with a kitchen knife. So it's the word, I think, rushes in particular. Let me just bold that. And I think then stabbing him several times, which certainly might suggest a frenzy. Now, linking that to the situation, which is going to be going into qualifying trigger, why has she done this? So again, if you read the scenario, it is centering on, well, apparently a suspected affair, or indeed his abuse of her. So I think I'm just going to highlight these points. Abusive relationship. Dan has become more controlling over a number of things. And I think what else? I think it's what he says here as well. So this is going to be linking to our next point I'll explain in a minute. So again, I'll probably put that in yellow too. So as you can see, just for a minute, these are the bits I think that are important. So if I'm going back to my answer, I've put A01 so far, this need not be some, there must be sufficient evidence of a loss of control, and I'm going to put here, in the scenario, this is my application, Nell has apparently lost control due to her anger over the abuse she has suffered, and furthermore a loss of control is indicated by the fact she, I'm going to put it in sort of quotes, she rushes into the kitchen and then stabs Dan, I think several times, which suggests a frenzy. So far so good, I think. Let's have a look through. Lost control due to anger of the abuse you suffered. So yeah, I'm pretty happy with that so far. I guess I could also say this does appear, doesn't it, from the scenario, that it was quite, after the confrontation, it was quite sudden, wasn't it? So maybe I should add that in, because of course, as we discussed, the old defence of provocation said there had to be a sudden loss of control, and if it wasn't sort of instantaneous, more or less, the defence would fail. But that was seen to be, as we said earlier, rather unfair towards women and sort of those who suffer domestic abuse, because men are more likely to snap, in anger with their testosterone and everything. And in abusive relationships, the power balance is clearly not there, because a woman, for instance, might be fearful because her husband's sort of beating her. And we saw, didn't we, in a case, though an old one, Alawalia, where a wife who was abused for over a period of time, many years, she waited until her husband was asleep before she actually ended up setting him on fire. But it was accepted that for women and in domestic abuse, it can build up over time. It can be cumulative. It wouldn't be maybe like men, where it just sort of a sudden snap. Now, I don't need to go into all of that detail necessarily here, but what I would say is, which suggests a frenzy and a sudden loss of control. So I think that's enough. Next bit. So what I'm doing is I'm going back to here. I'm looking at my second element that I've got. There must be a qualifying trigger, and all I would say here is you only need to write the qualifying trigger that is relevant. So if you think only A is there, you only need to write A. If you think only B is there, you only write B. But if you think both are there, you've got to write both. So again, you've got to make a judgment call. And looking at this, I would say that can we start with the fear? Is there fear of serious violence? There's no suggestion there that though abusive relationship, he's not sort of beaten her. He's, it's not sexually assaulting her. There's no fear of serious violence there. So I think I wouldn't bother to write that one. But what a lot of this seems to be is the second trigger, part B, which, if you go back, said things said or done of grave character. So I think here we've got a number of things. We've got his controlling behaviour in yellow. We've got the email with the suspected affair, and then we've got, lastly, I think, it's all in your head, she's a work colleague, nothing more, etc., but you're the world's worst wife. So this is how it's going to pan out for her, it seems, for Nell. You remember the excluded matters, one of which was sexual infidelity, or sexual jealousy, or indeed the other was revenge. Now, if there is any indication that Nell has killed Dan, having suffered a loss of control, over sexual jealousy or sexual infidelity, over this supposed affair with Sarah or the flirtatious behaviour, then the defence of loss of control is likely to fail because it will not convince a jury. That is one of the changes this defence made. Likewise, if we suspect that she has killed Dan out of revenge for saying what he did or allegedly doing what he's done, again, it won't work. So this is where the examiner, often for these sort of loss of control questions, scenarios, puts in some of these elements and expects you to discuss them, to identify them. So the only way, I guess, that this defence works for Nell is the abusive relationship part and saying that she's the world's worst wife. So I think those two things are more likely to work. So let's start putting this into our answer. We've got to do the A1 first. I'm going to do it as one paragraph. There must be a qualifying trigger. Remember section 55, so we'll put that in. With one trigger being, and this is the one I'm afraid that's a bit wordy, and we've got to try and get as close as we can, things said or done that are of grave character and leave the D feeling seriously wronged. Okay? Now at this point, I've just explained the law again, that second element. I'm going to apply it again. So it's this back and forth. So here we go. Nell may be able to convince the court that this was the reason she killed Dan, as she was in an abusive relationship abusive and controlling relationship, I should say, an abusive and controlling relationship where Dan was controlling. I think we said who she saw. I've got to remember myself now. Was it who she saw? Oh, what she could wear as well. Was controlling what she could wear, who she saw, what she could buy. Okay, so I think that is essentially things done. And then we wanted to say about later, Dan calls her, what was it, the world's worst wife, which could amount to things said. However, this is where we have to say about excluded matters. So this is me going back to AO1. So, however, excluded matters that the law will not accept as a qualifying trigger are, and then we're going to put here sexual infidelity. Ooh. And then I'm going to pop in the case of Clinton in brackets, or revenge. And then we're going to put Bailey. Again, if you can recall the section numbers for those two, by all means, but I'm just going to do that for the moment. I'm not going to mention the incitement, because she didn't incite the violence first in that scenario, like indoors, so we're going to leave that one. So I'm just going to put here, if the jury are convinced that this was the reason she killed Dan, namely the emails, wasn't it, she saw about Sarah and the allegation of and accusing him of an affair, sorry, I should put it that way, and accusing him of an affair, the defence will fail. All right, okay, so let me just give myself a bit more space, moving that up. We're back to AO1 now, so if we look back at our thing here, we've got the objective test. I'm not going to mention intoxication because of course that's not needed. So again, going back to AO1, we put the third element is an objective normal person test, which asks, would a person of D's sex and age with a normal degree of tolerance and self-restraint in similar circumstances have reacted the same way? And again, I'm just going to put in brackets whatever case you want to do. Let's do Van Dongen. Don't want to explain it, no need to. So now I'm back to applying it to the scenario, and this is where you've got to make your judgment. What circumstances are relevant here for her, as well as characteristics? Well, sex is referring to the fact she's female. Age, it doesn't say, so we assume just to be an adult. Otherwise the question would have said the scenario. And circumstances, I think the sexual infidelity, the allegation of an affair, while that can't be a qualifying trigger, it can be a circumstance that is taken into account. So it can't be the main reason, but it can be a reason alongside, with context. And also I think the fact she's in a controlling relationship. So I'm going to say this is a question for the jury, and in terms of circumstances, they can take into account the fact that she was in an abusive and controlling relationship, and the other part was I forgot myself. This question. It's going to come to me. I have forgotten. Abusive, controlling relationship. What was the other circumstance? World's worst wife, bit household money. I think that's it. I thought there was another one from it. It's gone from my head. So she was in an abusive and controlling relationship. The sexual infidelity. You're ahead of me, I'm sure. And the sexual infidelity. And then we just finish, don't we, by saying, you could even write, it's not an essay, so you can say something like, in my view, that's perfectly fine. In my view, it is likely that the jury will find that Nell killed Dan out of sexual jealousy, and the defense will fail as she lost control after an argument about the affair, or about the alleged affair, because of course Dan never said, did he? And I think what we would end with is, however, if successful, the should we put the charge of murder will be reduced to voluntary manslaughter, and I'll just put in brackets lesser sentence. So this is how I would probably approach answering this sort of question. And just very briefly, now it's been a slightly longer video, I wanted just to show you where we are. So if I do that in yellow, do that one in green. Oh no, want that yellow, don't I? There we go. Do that one, E, in sort of like a, I don't think that's like blue or a teal, and then we'll do that one in, oh, we haven't got very many good colours left, sorry, purple. So as you can see there, as I was going through, we identified who we're talking about and the defence, so that part is going to be our yellow. So you can take a highlighted pen afterwards and highlight to see your elements are all there. This is a statutory defence, so we said that bit would be in green. And then it's really just where the marks are back and forth between E and A. So all of this here was us explaining loss of control, the first element. And then in the scenario, this is our application and indeed AO3. So I'm going to pop that into the pink or purple. And then we went on to the next element. So I think that bit here is where we had our blue, and then when I'm referring to the name of the person and giving a view, that is going to be, of course, our application again. And then here, this is when we're talking about excluded matters, so that bit is going to be us explaining the law again. And then we give a comment when we apply it about that, so that would be the pink. And then we've got here the third element when we went on to that question for the jury. I think it probably strictly ended kind of there, didn't it? So I'm going to do that one in the, in the blue, because I think the bit about me mentioning the abusive relationship section fidelity is really just sort of starting to apply, isn't it, to the scenario of Nell. So that's going to be that. And in fact, all of that is going to be that pinky purple. And then the last bit when I'm saying about the defence, and basically also it's further analysis, it's further AO3 saying if successful this would lead to. So again, you know what, I can do it in pink. So there we are. There is our answer to this exam scenario of how you approach a loss of control question, which you would have roughly about just over, I suppose, 10 minutes or just over 10 minutes, unless you have extra time on top of, to answer this question. I hope this has been useful. I'm going to end the video here, but of course you can download these, the PowerPoint and the handout underneath the description.